My name's Adam Robinson. I'm the principal of Hollingworth and Spencer Solicitors. I've been doing this job for a little over a quarter century. One of the interesting things in looking after people and their small businesses has been the advent of how they engage with their business structures. About every week I come across clients who have family trusts, and for the greatest part they have no understanding of how their family trusts work or what in fact a trust is. I have for some years been explaining it to clients and would like to take the opportunity to share that understanding on a wider basis. That will help for the future and will help others who might need to know. By way of a background, the history of trusts relates to the Middle Ages. So an understanding of that history will help understand how trusts work and how they operate in 2021. The historical origin of the trust dates back to the time of the Crusades. Pope Urban II was the first who asked for the Crusades to start and called for people to go to the Holy Lands. A great part of Western Europe at that time was headed to the Holy Lands, and you won't be surprised to hear that the round trip in that day and age took quite a time to do. Now, sometimes Dad would be away for months, sometimes Dad would be away for years, sometimes Dad would not return. At that time, society wasn't as enlightened as it was today, and married women could not own property. So if Dad left the family estates to go on crusade, he had to leave it in charge of a family member. If the kids weren't old enough, then that was something that would need to be left in charge of a male family member. Let's, for the sake of argument, refer to him as Uncle John. Now, you won't be surprised to hear that not every Uncle John was a strictly nice guy. And after a very short time, a number of unhappy family members, mums and kids, started to turn up in the courts of law to say that Uncle John, for example, has taken money from the estates, Uncle John has taken crops from the farm, Uncle John has tipped us out on the street, sold our stuff and pocketed the lot. The courts universally came back to them with the one answer: who are you? Talk to the hand. Unfortunately, that's not a good enough answer even in that day and age, and so those unhappy people started to march out of the courts of law and into the courts of the King and Queen. After a period of some years, they started to be enough of a volume of people unhappily needing to be dealt with that the courts of the King and Queen formed another set of courts. Instead of the courts of common law, a brand new set of courts were created. And instead of just making new laws, they made new judges. And in the opening parts, they were actually priests. So the wisdom of Solomon was employed, and they said, well, the church created this problem, the church can solve this problem. And in doing that, they made the courts of equity. And the courts of equity looked at the situation, and being priests, they couldn't manage money, but they were allowed to look after the people. So after a brief check of the facts, what they started to do is to say, hey, John, you have a trust imposed on you. Your job is to look after mum and the kids. In that role, you're not doing your duty. So what we're going to do is to lock you up. Now, you let us know when you're ready to do the right thing by mum and the kids, and we'll get you straight out. But until then, we're just going to pop you in jail. Now, you won't be surprised to hear that they got some very quick response time out of the family members in that situation. That scenario is the absolute origins of a trust. John, in this example, was the trustee. The objects of the trust were mum and the kids, and the role that's played by the mum and kids is the role of beneficiaries. The discretionary assets that were being administered by John on behalf of the beneficiaries are the family estates, and even in that day and age, there was the role of an appointor. So Dad, prior to departure, placed the responsibility on John as both the settlor of the trust, who placed the assets under his control, transferring them into his name as the legal owner while Dad was away, and as the appointor with the right to remove him as and when Dad returned from the Crusades. Indeed, in some of these cases, Dads did return from the Crusades and John simply refused to hand the assets back. So to our day and age, we still have trusts, and trusts are administered in much the same way with the same core roles. Every trust that exists has a settlor, has a trustee, and has beneficiaries. The trust that mum and dads these days normally will deal with in their estate or as part of their ongoing business and family arrangements is a discretionary trust. There are other kinds, but that is by far the most common. A discretionary trust allows the trustee an absolute and unfettered discretion over what assets or income of the trust to apply in favour of the beneficiaries from time to time, and how much of those assets to distribute at those times. The beneficiaries, again, in more common modern trusts, are indeed the normally mum and dad as the primary or tier 1 beneficiaries. The secondary beneficiaries are normally the immediate family members, children, grandchildren, parents, grandparents, siblings, spouses of any or all of the above would ordinarily be allowed in as secondary beneficiaries, and trusts routinely will allow tertiary beneficiaries, such as companies that one of the primary beneficiaries or secondary beneficiaries hold shares in, trusts they receive distributions from, or sometimes charities that the trustee is interested in. There remains still the role of appointor, and that role is one with the right effectively to hire and fire the trustee. And coming back to the common example of mum and dad having their family trust, it would normally be either mum or dad or both mum and dad with that right to hire and fire the trustee.